Hello, constitutional law students. This is a brief lecture on the following topics related to executive power. How the Constitution limits executive power, how Congress has extended executive power, and how the courts have adjudicated disputes over the scope of executive power. We'll start first with constitutional limits on executive power. Even the founders of our country lacked a true consensus on the scope of presidential power, but they did agree that the national government would be a limited government. Although they left some amount of flexibility in the Constitution so that the national government could adapt as new issues and concerns emerged, the Constitution does not give the president unlimited power. Here are some ways that the Constitution limits presidential power. In various places through the Constitution, the president's powers are enumerated. And as I've spoken to you about other branches of government, the process of enumerating or listing powers is itself a process of limiting them. We're saying what they are rather than letting the particular holders of public office to decide what their powers are. We've defined them, told them what they can do, and thereby limited their power. So, for example, the president's powers are categorized sort of loosely in this way. Article 2 gives the president the job of appointing officials of the national government, including federal judges and ambassadors. Article 2 gives the president the power to negotiate treaties, to receive ambassadors from other nations, and to lead the military. So it has defined certain powers related to foreign affairs. And third, both Articles 1 and 2 give the president the power to influence the lawmaking process. Now, principally, the executive power is the power to execute the laws that Congress writes. And we see that at the end of Article 2, Section 3, where the president is given the responsibility to take care that the laws of the nation are faithfully executed. But the president also has the power to veto a law, and the president has the power to offer legislative proposals to Congress. So the president and the Congress are required to cooperate with one another in the lawmaking process. Nearly every enumerated power of the president requires the substantial consent of the Senate. Now, one notable exception to that you will see in our textbook is the power to pardon. And you can read that section and see that that is a very broad and exclusive power of the president. But otherwise, the powers of the executive branch are limited by the checks and balances process, where Congress, particularly the Senate, has to give its usually two-thirds approval of an act of the president. The founders of our country then limited the president's power by requiring his cooperation and respect for the other branches. That's just the principle of separation of powers in action. It's there just to prevent the gradual concentration of power into a single person or group. Over the course of history, presidents have exercised power in ways that the founders may or may not have anticipated. The textbook refers to this as inherent powers, or the power to do things that presidents ought to be able to do in the context of a Republican government, but they may not have been expressly granted to the president in the Constitution. But inherent powers are problematic. What they include has been determined by what presidents have simply done and gotten away with. In many ways, presidents have had the liberty of defining the scope of their own power. However, as I've explained, the Constitution places limits on the president's power. So one way to look at inherent powers is this. The president has the power to do what is necessary to carry out the law, to defend the nation, and to be the nation's representative on the world stage. That power is subject to limits imposed by the Constitution, particularly limits that uphold the separation of powers and limits that prevent the president from infringing upon the liberties of the governed people. And there are several examples of those limitations reflected in the case excerpts that are presented in Chapter 5 of your textbook. So those are the limits on executive power. But now we can compare that to some degree of expansion of power that has come through the acts of Congress. In addition to the U.S. Constitution, Congress has enacted laws that have increased the responsibilities of the president and given the president the discretion to take action to implement public policy. Now, one example of this is Congress has delegated the responsibility for the creation of a national budget to the president. Although Congress ultimately approves or disapproves of the budget, the executive branch has a great deal of authority to establish the national budget and to spend it accordingly. Another example relates to emergency powers. There is a web of laws enacted by Congress over the course of many years that allow the president to take action in an emergency. Keep in mind that there is no general emergency power authority given to the president through the Constitution, but Congress has passed a variety of specific laws that allow the president to identify a situation as an emergency and then take action to respond to that emergency. So you can see now that there are two sources of executive power. The Constitution, the primary one, the U.S. Constitution, but also acts of Congress. Now we'll look for just a minute at the way the Supreme Court has set precedents on the scope of executive power. If a president takes an action that is not authorized by one of the two sources I mentioned, the Constitution and acts of Congress, it is likely that the U.S. Supreme Court will strike down that action as an abuse of power. But remember, the court cannot take any action until it is asked to. The courts do not have a will of their own. People must bring disputes to the courts to resolve. It is only when a justiciable case or controversy is brought to the court involving the scope of presidential power that the court may say what the law is regarding presidential power. And even though the court is the branch that says what the law is, the court cannot enforce its own decisions. It depends upon the other branches to obey its rulings. This is known as the problem of judicial implementation. If Congress or the president does not respect the authority of a co-equal branch of government, then the decisions of the court will be meaningless. So to a large extent, the institution of American government is a game of trust. Let me emphasize here a few of the general principles that you should draw out of your reading from the textbook in this module. When the president is acting with express authority from the Constitution or Congress, the courts are likely to uphold the president's actions unless it violates the liberties and rights of the citizens. When the president acts against the will of Congress and without authority from the Constitution, the court is very likely to strike down those actions. But in times of war or national emergency, the president is afforded greater deference than the president would be in times of peace. You can see these points illustrated when you compare and contrast two U.S. Supreme Court decisions. Youngstown Sheet and Tube Company versus Sawyer, that's the steel mill case, and Korematsu versus United States, involving the internment of Japanese Americans during World War II. Each of those decisions is discussed in the textbook, but the application assignment for this module requires you to study them more deeply. The Youngstown case is presented through excerpts in your textbook and through an article that I've provided in the module for you to read. You'll also need to read and brief the Korematsu decision, which you can find through the Jackson Library's Westlaw Research Database. In an assignment with this module, you'll be asked to read and compare these two cases and look for the reasons why the court arrived at different conclusions. My intention by this assignment is to help you recognize a pattern in the law for when and how presidential power is appropriately exercised. That's really all I have to cover in this module lecture. If you find any of the material in Chapter 5 of the textbook difficult to understand, please do not hesitate to reach out to me for more explanation. I'm here to help, and I can be reached by phone or email at any time.